Good morning. We are now to start with international contract law, international contracts in commerce law. Next Tuesday we are going to have a meeting through Teams. I'm going to provide you with the link after posting this video, and we can comment the issues we are going to see in the video and other problems. And I hope that in a few days before our meeting next Tuesday, you are going to have also the grades of the last exercise. And we can also comment the grades and the exercise. But now we are going to focus in international contracts in international commerce law. We have considered some points in the previous lessons because it's impossible to deal with some matters without considering contracts. But now we are going to see contracts properly in a very specific way. And well, this is always a difficult lesson because many of you have already studied private international law. So some of the things, or most of the things we are going to see in this lesson, you already know them. But as some of you are coming from another countries, from another continents, and you don't have a lot of knowledge about the regulations in the European Union, I think that it's necessary to explain in some detail the regulations about contracts from the point of view of international jurisdiction and also from the point of view of applicable law. For those of you that have already studied private international law here in Europe, not necessarily in Spain, but in Europe, maybe some of the contents of this video are going to be very, very easy. First, contract. I know that all of you know what a contract is, but I think that we must say something about a contract at this point at the beginning, just to remember what is a contract. A contract is a legal binding agreement. So we are talking about agreements between at least two parties that establishes rights and duties. Through the contract, there is a new relationship between the parties of the contract, and in this relationship, these parties have rights and duties. And this is legal binding for the parties. This is a difference with another kind of agreements, sometimes called gentleman agreements. That implies that they are not binding for the parties. When we are talking about a contract, we are talking about a binding agreement. And if the contract is binding for the parties, it's because the law establishes this binding character, this mandatory character of the contract. And this is the first point that is important to consider. The contract is an agreement between the parties and is binding, but is binding because of the law. As the law establishes that the contract is binding for the parties, then the contract is mandatory rule for the parties, even considering that the specific content of the contract is not given by the law, but is given by the parties. This is the first idea. Agreement between the parties, party autonomy, but binding because of the law. but the content is created by the parties. The contract is composed by contract terms that are the clauses that the parties determine to be included in the contract. This is the reason that explains that before I was talking about the private content of the contract, that the law makes the contract binding, but the content of the contract is given by the parties, not by the law. In principle. Why in principle? In principle, because for saying that the law establishes that parties can agree on whatever they want with certain limits, we are going to see that, and the law refers to the parties the content of the contract, but it's the law who makes that content binding. But usually parties don't cover all the issues related with the relationship they have created. Usually there are some problems that arise during the relationship between the parties that are not covered by the contract terms. And then we must find a solution when there is something that must be resolved in the relationship between the parties, and this issue is not covered by the contract terms. We should find a solution. And where are we going to find this solution? Well, in the law. The law is not only making binding the contract, but the law is also covering the holes that we can find in the contract, the gaps that are not covered by the contract terms. For example, we can deal with a contract on the sale of goods, and both parties agree on on an operation that implies that some goods are going to be sold to one of the parties. But in the contract terms, parties don't determine the place of the delivery of the goods. It can happen. It is not very strange. There are a lot of many important things, even in contracts, that have not been agreed by the parties. So when this happens, when, for example, we have a contract, we know that one of the parties must deliver some goods to the other party, but we look at the contract and we don't find in the contract, in the contract terms, where the goods should be delivered. So then, in that case, we should go to the law, and then the law usually establishes these kind of solutions for the gaps we can find in the contracts, in the contract terms. So the law also completes the contract. The law not only makes binding the contract, but also completes the contract. The rights and duties that necessarily should be in the contract and that have not been covered by the contract terms, we can find these rights and duties in the law. And this is a second aspect of the relationship between the law and the contract. And the law also limits the freedom for the parties, the autonomy of the will of the parties, because there are some clauses that could be forbidden in the contract. There are limits established by the law. For example, in many countries it's not possible to establish an interest too high for a contract. When somebody is loaning money to the other person, in principle you must establish an interest in favor of the person who is loaning the money, but this interest cannot be higher up to certain point, for example. Or there are some kind of obligations that are illegal. It's not possible for the parties to agree on certain obligations that can be against the moral or the law or whatever you can imagine. These are limits also for the contract, and these limits are established in the law. So, as we have seen, contracts mean the freedom of the parties. The parties are free to create a new relationship with rights and duties to each other. This is binding, legally binding, according with the law, and the law also limits the contents of the contract and completes the contract. These are the three main aspects of the relationship between the law and the contract. But these are very important aspects. It's very important for the contract, the relationship with the law. And we are not talking about international commerce law at this point. We are talking about contracts in a pure domestic sense. This is contracts according with Spanish law, German law, English law. I think that probably the things I have just explained are the same in almost all the countries in the world, because are very basic considerations about contract law. Now we are moving to international commerce. A domestic contract is a contract linked only with one country, with one law. To be more precise, it's not the same one country or one law, but we are not going to enter into that now. A country connected with one law. We have an international contract when this contract is connected, is linked with more than one law. And this connection can come from the nationality of the parties, or the establishment of the parties, or the place of the performance of the contract. For example, if we have a contract between two Spanish companies and the contract should be executed, should be performed in Spain, we are in a pure domestic contract. But if we have a contract between a Spanish company and a Portuguese company, then we are before an international contract. And even if we have two Spanish companies in the sense that they have been incorporated according with the Spanish law, remember lesson 3, but the main headquarters of one of the companies is located outside Spain, then there is a strong connection with another law. So in that case, as one of the main elements of one of the parties in the contract is connected with another country, then we are dealing also with an international contract. And we can be also before an international contract, even in the case of two companies incorporated in the same country and with main headquarters, main administration, main place of business in the same country, in the case that the performance of the contracts must be made in another country. For example, two Spanish companies agree on a contract aimed to the building of a factory in Mexico, for example. They are two Spanish companies, but the contract is going to be performed outside Spain, another country. So there is a connection with another country. This is another example of international contract. So we have an international contract when the contract is connected with more than one country. That means with more than one law. This is an international contract. And now we are going to consider at the same time the both issues we have dealt with till now. First, we have an international contract because the contract is connected with more than one law. Second, it's very important for a contract the connection with the law, because the law makes the contract binding, completes the contract, and limits the contract terms. In pure domestic cases, the connection between the contract and the law is very easy to establish, because as we are in a pure domestic contract, the law who is going to cover this contract is the law of the one single country that is connected with the contract. So in a pure domestic contract between two Spanish companies, for example, we know that the law who makes the contract binding is Spanish law, the law who limits the contract terms of the contract is also Spanish law, and the law that limits the contract terms is also Spanish law. So Spanish law determines the binding character of the contract, completes the contract, and establishes the limits of the contract terms. So if we want to know which are the duties and rights of the parties, we have to consider just the contract terms, the terms agreed by the parties, and the Spanish law. Then we have the whole picture of the rights and duties of the parties. This is in pure domestic cases. But what about international contracts? Well, we always have a doubt. We always have the doubt about which law is the law governing the contract, because it's not clear, because the definition of pure domestic cases, the international cases, is a definition based on the connection of the contract with different laws. So the idea is that as there are different laws connected with the contract, it's necessary to determine which is the law governing the contract. Sorry for a moment, I need to stop just 30 seconds. Por favor, niños, no me puedo concentrar, dejadlo, no puedo seguir con el vídeo si estáis así. Sorry for a moment, it's my children that are playing next to me, but I think that they are going to be still from now. As we are dealing with international contracts, we don't know which is the law governing the contract, and this creates an essential uncertainty in international commerce. it's, I think, very important to realize that it's a key element to understand what happens in international commerce with contracts. And it's so strange as it sounds, is that in international commerce you never have 100% certainty about which are the rights and duties of the parties in a contract. And this is very important because, of course, when we are in commerce, it's important for the parties to know which are their rights and duties. In international commerce, it's impossible to know it. It's impossible, really impossible, really impossible. Why? Because the law governing the contract depends on the private international law system of the court. That is, if we are considering the contract from the point of view of the Spanish private international law system, the law governing the contract might be one. And if we are considering the contract from the point of view of the Mexican private international law system, the law governing the contract could be a different one. As each country has different systems of private international law, the law governing the same contract could be different according with different private international law systems. So we cannot say which is the law governing the contract. We can say that according with the private international law system in that country, the law governing the contract is that one. But there is no universal answer to this question. The answer depends always of the point of view of the country we are going to consider. And which country is the country that we should consider? The country who is going to resolve the dispute between the parties. The law, the private international law system of the court. So before the dispute, it's not possible to know exactly which are the duties and rights of the parties. Before the dispute, it's not possible to know that exactly. And because it depends on the jurisdiction who is going to resolve the dispute, and which is the competent court. Well, we don't know. I think I mean we don't know 100% because the plaintiff can introduce the claim before one court in one country, and that court in that country is going to determine its jurisdiction according with its law, the law of the country of the court. And the plaintiff can introduce the claim in another court in another country, and the court in this different country is going to determine its jurisdiction according with the law of that country. So different countries can assume jurisdiction, so we are not sure about the competent court, the court who is going to assume jurisdiction before introducing the claim. You can have an idea, we are going to see, you can have an idea, but you cannot be sure 100%. And I think that is important to assume that this idea, the idea that at the end, we are only to know exactly 100% the content of the contract before the resolution of the dispute before a court. Before that, before the resolution of the dispute before a court, we are not going to be sure about the rights and duties of the parties, because, as I have explained, the rights and duties of the parties are not only the rights and duties coming from the contract terms, but are also they are also affected by the law governing the contract. And we don't know the law governing the contract before introducing the claim, because that law governing the contract depends on the private international law system of the court. And we don't know the court before introducing the claim, before the jurisdiction of the court will be determined in that moment, and for the same contract, several countries, several courts in several countries can be competent. So before that moment, before the moment of the dispute before the court, you cannot be sure 100% of the content of the contract, of the rights and duties of the parties. And of course, there are a lot of contracts that never arrive at a dispute. Fortunately, there are more contracts that are living without a dispute that arrives before a court than contracts with dispute before the courts. Fortunately, this is the situation in domestic contracts and also in international contracts. Most of the contracts are fulfilled by and performed by the parties without dispute, and when there are some kind of discussion, most of the times the discussion is resolved by the parties without the need of a judgment issued by a court. So, in many cases, the players in the international commerce are applying contracts without knowing exactly 100% which are the duties and the rights of the parties of the contracts. They have an idea about that, but as I have explained, they are not sure 100%. This is an essential uncertainty in international commerce that we must consider. We must pay attention to this uncertainty. I like to say that it's like the case of the Schrödinger cat. You know, that idea coming from the quantum physics, that is not possible to know the Heisenberg uncertainty also, that is not possible to know where exactly an elemental particle is at that in a certain moment. You can only know the probability of finding that particle in that moment. And in the case of the Schrödinger cat, you know, you have a cat in a box. There are 50% of possibilities of that the cat is alive and 50% that the cat is dead. And it's not possible to know whether the cat is dead or alive before opening the box. And at the moment you open the box, you know if the cat is alive or dead. And before that moment, and this is the point, is not that you cannot know whether the cat is alive or dead. It's that the cat is at the same time alive and dead. This is the point of the case, because there is no joke. We can only say that we don't know simply whether the cat is alive and dead. This is evident. But the point is that if we translate that to quantum physics, that implies that really the cat is alive and dead before we open the box. So think about that from our point of view. Before going to the court, this is opening the box, we don't know the rights and duties of the parties. There are only a probability that rights and duties of the parties are going to be in that way. But it's necessary to open the box, in that case, to go before the courts to determine exactly the content of the contract. But in international commerce, as I have said before, many cases we never open the box. We are playing with probabilities, the probabilities about which are the rights and duties of the parties. Why am I explaining all these things, even the Schrödinger cat? Well, because we need to understand this to understand the tools that are used in international commerce to limit this uncertainty. For economy, for business, uncertainty is never good. We like the situations in which we know what is going to happen, and we don't like situations with uncertainty. We are not playing cards here. We are trying to be sure about what we are going to do and what we are going to find. And in international commerce, as I have just explained, we have this essential uncertainty. And how we can deal with this uncertainty in international commerce? How can we have a higher probability of certainty about the rights and duties of the parties without opening the box? That means without going before the cards. Well, we have different tools in order to resolve this. Which tools are these? Sorry for a moment again. Héctor, Amanda, estoy grabando. Por favor. Por favor, vale ya. No voy a parar la grabación. Voy a seguir grabando y está saliendo todo esto. Por favor, vale ya. Sorry. As I have explained to you, we need to be aware of this situation, of this uncertainty, to understand the tools we are going to use in order to resolve this uncertainty. And first point, uncertainty about jurisdiction. Well, which tool we have in order to limit uncertainty about jurisdiction? Well, the tool is choice of court. The parties can introduce in the contract a contract term, a clause, establishing that they choose the court of one country or a court in one country to resolve any dispute arising from the contract. Well, you can imagine, well, when the parties have agreed on the court, then this court designated by the parties is the court who is going to assume jurisdiction. Well, in most of the cases, but this is never sure 100% also. Why? Because the contract term, the choice of court agreement, should be valid according with the rules governing jurisdiction in the country of the court chosen by the parties. If the parties have chosen, for example, the courts in Rome, Italy, for resolving any dispute arising from the contract, then it's necessary that this choice of court agreement will be valid according with Italian law. When the chosen court agreement is not valid according with Italian law, then the election is not effective. The Italian courts, the Rome courts, are not going to assume jurisdiction. So you must write, if we are talking about a writing clause, you must write the agreement, the choice of court agreement, in a way that makes that agreement effective from the point of view of the courts designated in the agreement. This on one hand. On the other hand, we have in this example a choice of court agreement in favor of the courts in Rome, Italy. But what happens when one of the parties introduces a claim before, for example, the courts of Lisbon in Portugal? So, in that case, we must consider also whether the choice of court agreement is valid and effective according with Portuguese law. Because if according with Portuguese law, this choice of court agreement is not valid, at the end, the courts in Portugal are going to make, depending on other factors, but it's not impossible that courts in Portugal assume jurisdiction in the case. So, if the parties try to centralize the dispute in Rome, Italy, in order to avoid uncertainty, and the clause is not valid according with the law of the country in which the court designated are located, or the choice of court agreement is not valid according with the law of another country that could assume jurisdiction in the case, then the objective, the goal the parties intended, the goal that the courts, only one court is going to know about the dispute in order to avoid uncertainty, is not going to be fulfilled. So when parties introduce a choice of court agreement in the contract, and the choice of court agreement is well made and it works, then you reduce uncertainty because you can hope that the court designated are going to assume jurisdiction, and different courts in different countries are not going to assume jurisdiction. But this could not happen in all the cases. So there is certain uncertainty in that case. But the using of choice of court agreements is useful in order to limit uncertainty in international commerce law. This is the first way to limit uncertainty in international commerce, to use choice of court agreements. And of course, also it's another tool to use not choice of court agreements, but arbitration clauses. So to agree on resolve any dispute arising from the contract before and before arbitration, using arbitration. Choice of court agreements or arbitration have the same meaning in international commerce to reduce the uncertainty in the at the end in the determination of the rights and duties of the parties. Well, in this year we are not going to be able to deal with arbitration, so it's a pity. But if you have interest, we can comment arbitration in any of the meetings we have through Teams, or in if you want in a tutorial session through Teams. Also, if you have interest in some aspect of arbitration. These are two ways to limit uncertainty in international commerce, two ways relating with jurisdiction: choice of court agreements and arbitration clauses. Other way, choice of law agreements. That means parties can also determine which law they want to govern the contract. They can introduce a contract term establishing that, for example, the contract will be governed by English law or Spanish law or German law or French law, whatever you want. We're going to see that in a moment. Of course, this kind of clauses, this kind of agreements between the parties determining which is the law that is going to govern the contract are only effective when they are considered effective according with the law of the according with the system of private international law of the court that is going to resolve the dispute. That means when the parties agree on a choice of law agreement, an agreement on the law governing the contract, but the system of private international law of the country of the court who is knowing about the dispute determines that this choice of law is not valid or is not effective, then it's not useful to reduce the uncertainty. But usually this kind of clauses, this kind of agreements on the law governing the contract are admitted by the systems of private international law. So, as usually these kind of clauses are admitted, then parties know that there are many there are a high probability of at the end considering effective this choice of law clause. So when we add these two ways, first parties choose the court, and at the same time parties choose the law governing the contract, the parties can have reduce the uncertainty about the content of the contract. If the parties choose a court and they know that the system of private international law of that court considers effective the clauses in which the parties choose the law governing the contract, at the end the parties are pretty certain that the law governing the contract at the end will be the law chosen by the parties. So they can consider that the the content of the contract, the rights and duties of the parties, will be the rights and duties determined by the contract terms and the law designated by the parties. When this designation of the law in the contract is is um, is um, is considered jointly with a choice of court agreement. So the use of a choice of court agreement and a choice of law governing the contract, it's a tool for reducing uncertainty in international contracts. So I hope that this is clear. We have seen that there is an essential uncertainty in international contract law, because contract is not only the contract terms but also the law governing the contract. That it's very important for the contract because makes the contract terms binding, limits the contract terms, and completes the contract terms. In international contracts, we are not sure about the law governing the contract, and this is a legal uncertainty that we cannot resolve 100% before introducing a claim before a court. This is like the Schrödinger cat. In that case, opening the box is introducing the claim before the court. How parties in international commerce deal with this problem? Trying to reduce the uncertainty. And there are two main ways to reduce uncertainty. First way, they choose the court who is going to be competent to resolve any dispute arising from the contract. Or introducing a clause about arbitration. So any dispute about the contract will be resolved by arbitration. The second way, introducing a clause of about the law governing the contract. When we use both of them, a arbitration clause or a choice of court agreement and a choice of law governing the contract, we reduce the uncertainty linked to the contract. And this is important because it's the way to determine the exact content of the contract, the rights and duties of the parties. I hope that this is clear. If it's not clear, remember we have the meeting on Tuesday to resolve all the doubts you have. Is that okay? Yeah. So now we are going to move to the rules governing jurisdiction, and we are going to study regulation 1215 2012. You already know this regulation. We have studied this regulation when we were talking about patents, intellectual property, unfair competition. So it's familiar for you. We are not going to enter into scope of application because we have already studied this scope of application. You know that is enforced in all the European member states, exception made of Denmark, but in Denmark it's also applied through an agreement between the European Union and Denmark. So at the end, in all the European Union member states, regulation 1215/2012, regulation Brussels 1 bis applies, until the last day of this year also applies in the United Kingdom. So all these things are already known. We are to move to the rules governing contracts in the regulation. And we have to pay attention to the general rule of the regulation, that is a combination of Article 4 and Article 6 of the regulation. We have already studied these rules in unfair competition or intellectual property, so you know already that. It's just to remember that according with Article 4 of the regulation, when the defendant's domicile is in a member state, then the courts of that member state have jurisdiction on the merits. And when and the other courts of member states, the courts of member states that are not the defendant's domicile, have no jurisdiction, exception made of that courts with jurisdiction according with another rules of the regulation. In our case, Article 7.1, as we are going to see. But the first idea is that the competent courts, the courts with jurisdiction, are the courts of the country where the defendant has its domicile when this domicile is within the European Union, is in a member state. Article 6. When the defendant's domicile is in a non-member state, then in each member state the jurisdiction will be determined by the domestic rules of that state. That means when we are dealing with a case in which the defendant's domicile is in the United States and the plaintiff introduces the claim in France, then the French courts are going to determine its jurisdiction according with the domestic French law. When the defendant is domiciled in Russia and the plaintiff introduces the claim in Italy, the Italian courts are going to determine whether they have jurisdiction or not according with the Italian domestic law. This is Article 6 of the regulation. And these are the general rules on jurisdiction in the Brussels 1bis regulation. But these rules don't apply when we are in matters considered as exclusive according with Article 24. We are going not to enter in Article 24 of the regulation now, because when we are talking about contracts, in principle, Article 24 is not relevant. Well, it's relevant in some slight cases we are not going ever to mention now. Because in most of the cases there is no relevance at all of Article 24. So we are going to forget Article 24 at that moment, and we are going to move to other two articles that are that prevail over Article 4, Article 6. These articles are Article 25 and Article 26 of the regulation. Article 25, choice of court agreement, prorogation of jurisdiction. That means when the parties decide to determine the court that is going to have jurisdiction. Article 25 of the regulation Brussels 1bis. If the parties, regardless of their domicile, have agreed that a court of the court of a member state are to have jurisdiction to settle any dispute which have arisen or which may arise in connection with a particular legal relationship, that court or those courts shall have jurisdiction unless the agreement is null and void as to its substantive validity under the law of that member state. Such jurisdiction shall be exclusive unless the parties have agreed otherwise. The agreement conferring jurisdiction shall be either, and now the formal requirements. So this article provides a regulation about the possibility of the parties of choosing the court. Which requirements we need in order to have a valid and election? First of all, we must choose a court in a member state. This Article 25 only applies when the court chosen is in a member state. What happens with elections, election of courts in non-member states? Where there is no clear solution for that, but the most followed interpretation is that the domestic law of each member state is going to determine the validity and whether this election is effective or not. I mean, if we have in a contract the election of a court in the United States and the plaintiff introduces the claim in Spain, the Spanish courts are going to determine the validity of the election according with the domestic rules in Spain governing jurisdiction, Ley Orgánica del Poder Judicial. As the election is not made in favor of a court in a member state, Article 25 of the regulation doesn't apply. And the courts in member states are going to determine its jurisdiction according with its domestic law. This is the approach followed in many cases. So it's not that is not admitted the election of a court in a non-member state. Is that in that case, in the case of the election of a court in a non-member state, the validity of the election is going to be determined by the domestic law of the court in a member state where the plaintiff introduces the claim. I hope that this is clear. But when we are applying Article 25, if we want to use Article 25, we should make the election in favor of a court in a member state. This is the first requirement: jurisdiction, election of the court of in a member state. To have jurisdiction to settle any disputes which have arisen or which may arise in connection with a particular legal relationship. That means the election must be made in relationship with a specific relationship, a contract, for example. That means it's not possible a general submission, a kind of submission in the sense that company A establishes that any dispute with company B is going to be resolved by the courts of Munich, for example. This is not valid because there is not a submission connected with a specific relationship. The requirement is that the submission should be connected with a specific, a particular legal relationship. In the case we are dealing with, international contracts, there is no problem. We are talking about contracts, so a contract, a specific contract in which there is the clause. So the clause, the prorogation of jurisdiction in international contract usually is linked to the contract, and there is no doubt about this requirement, the requirement that the submission must be connected with a particular legal relationship. Which could be the doubt here? Well, the doubt is, what about disputes between the parties connected with the contract, but that don't have a contractual nature. It's very common also that when there is a dispute between parties connected with a contract, some of the claims are based on contractual law, and some claims are based not on contractual law but in torts, for example. We have considered that, remember, when we were dealing with unfair competition, because in unfair competition it's very common, well, very often, there is a contract, there is a breach of the contract, and at the same time there is a breach of obligation coming from the rules on unfair competition. So we have proceedings between the same parties, and part of the proceedings are based on contractual obligation, and part of the proceedings are based on torts. This can happen. It's not very strange. So we have already commented that when we dealt with unfair competition, but we are going to repeat that now. Is that usually the prorogation of jurisdiction clauses cover both fields, cover not only the disputes between the parties connected with the contract based on contractual law, but also the disputes between the parties connected with the contract or that based on tort rules. Well, of course, it depends of the writing of the wording of the clause. When the wording of the clause is any dispute based on the breaching of the contract according with rules on contracts, for example, in that case, it seems that the parties wanted to exclude disputes based on tort rules. But this is not very common. The usual clause is similar to the wording of Article 25. Any dispute arising in connection with the contract, or any dispute connected with this contract. And with this kind of wording, the most follow interpretation is that not only disputes based on the infringement of rules of contractual nature, but also the disputes the claims based on the infringement of tort rules are covered by the clause. So the clause could cover dispute based on contractual rules and on tort rules when the dispute is connected with the contract. Another requirement, the requirement that the clause should be valid under the law of that member state. That means the member state of the court designated by the clause. This is a novelty in the Brussels 1bis regulation, covering a dispute more from a theoretical point of view than from a real point of view. Point is that Article 25 covers many aspects of the validity of the prorogation of jurisdiction clause, as we are going to see. Even formal validity, that's a very important point, but we are going to see that point in the next video, because I realize that now we are more than 1 hour and we have no time for explaining all the things related with the formal validity of the clause. But as I'm saying, Article 25 covers a lot of questions related with the validity of the clause, but not all the questions connected with the validity of the clause. For example, capacity of the parties. Have the parties capacity to conclude this agreement? Well, this is not covered by the Article 25. So there was a debate about which rule governs these aspects of the validity of the clause that are not covered by Article 25. In Article 25 now, I think now because in the Brussels 1 regulation, this was not there was not a rule about that, but now Article 25 of Brussels 1 bis regulation provides a solution for that. And the solution is that we are going to apply the law of the country of the court designated by the parties. I'm not going to enter into the different possibilities we have because at that point we have a solution and this solution is pretty clear, so I think that we can rely on this solution. The questions linked to the validity of the contract that are not covered by Article 25 are going to be covered by the law of the country of the court designated by the clause. And this is easier, this is more simple than the solutions that were in discussion before this Article 25. So we have requirements. The submission should be made to a court in a member state. The submission should be linked to a particular legal relationship, but when the submission is connected with a particular legal relationship, this is also going to cover not only contractual claims but also claims based on torts. And another point is that the agreement cannot be used in matters of exclusive jurisdiction by virtue of Article 24. And this agreement can be in accordance with the specific regulation about weak parties. That means regulation about insurance, about consumer contracts, and about individual contracts of employment. This is in Article 25.4. So we have that in Article 24 prevails over Article 25, and it's not going to we don't have the possibility of a jurisdiction, a prorogation of jurisdiction that excludes exclusive jurisdiction based on Article 24, and the jurisdiction clauses should be in accordance with the provisions related with or relating to with parties, weak parties. That means insurance, consumer contracts, and individual employment contracts. Articles 15, 19, and 23 of the regulation. And this is in Article 25.4 of the Brussels 1 bis regulation. And now we should enter into the formal requirements of the agreement, but as this is a little bit longer, we are going to do that in the next video. In the next video, we are going to see the part we haven't considered here about jurisdiction, applicable law, and I hope we have time to enter into Vienna Convention of 1980. Then, as you know, next Tuesday we have that meeting through Teams till Tuesday.